All right. Want to welcome you all back. We do have people joining us via the internet, a webinar. But before we get started, I want to do a quick introduction of myself. I know most of you. My name is Levi Esquera, and I'm from Parker Valley. I grew up on the Colorado River Indian Reservation, the tribe there. And I am thrilled that in the house today, we actually had the Madam Chairwoman of the Colorado River tribe. She is not only the chairwoman, but she's also a friend. It doesn't get better than that to have you here, Madam Chairwoman Flores. However, although I have a brother and sister who are members there, I'm actually enrolled up the river a little bit at the Chemehuevi Indian Reservation. And I'm equally thrilled that we have my chairman here with me as well, Chairman Lodge. So thank you for being here, Chairman, as well. We also have some great other friends that I have here, tribal leaders that I'm thrilled with. First is we have from the Salt River Pima Maricopa Indian community, Micah Carlos. I met Micah, I don't know, but it seems like lately I've been running into you all the time now. Micah's going to be a permanent resident here at the University of Arizona. So it's great to have you in the house. And then for our entertainment, we have some of my friends from White Mountain Apache. We have council member Gary Alchase. Gary is he's a true cowboy from what I understand, not the one that just shows up at the rodeo, but he actually has a lot of heads of cattle that he manages. So we're thrilled to have them in the house. We're going to have some other tribal leaders and dignitaries joining us throughout the day. The other thing that we actually have here is we actually have representatives from San Carlos Apache and Coquille tribe. And joining us via the internet, we have representatives from Navajo Nation, Pascua Yaqui, San Carlos Apache, Tohono Nation, and Yavapai Apache Nation. We also have joining us other federal agencies. We have students from our law school that we're thrilled about, other legal professionals, and everyone else here. I want to thank you for being here. And now I know I told you this story, and I just want to tell it real quick how this conference came to be. This is a unique form. You know, yesterday I was spending a little bit of time talking with Tina, and I prefer quality over quantity. I am grateful you're here today because of the subjects we're going to be talking about. A little over a year ago, my team and I were meeting with President Javier, the Salt River Pima Maricopa Indian community. And as we were leaving, some of his community managers and people were coming in, and he says, you know, Levi, I'm getting ready to go into this meeting. Going to be with lobbyists, our attorneys, and we're going to be talking about Supreme Court cases and how they're impacting our tribe. And he says, I know University of Arizona, you have resources, and maybe some of the tribes aren't as blessed as us, and this would be an opportunity for you to actually provide. So that's how this came to be. And I am thrilled that we have the Haury Foundation who has stepped up to assist us. And to my left, we have Toni Massaro, we have Nina, and we have Nancy with us as well. And then we teamed up with the best law school, right? Native American Law School. Yeah. Look at the rankings. We get an A plus, right? I think we're only, okay. I look at rankings, especially when we're like 1 or 2. But can I say something really cool about our law school? Last year, 10% of our first year cohort were Native Americans. Think about that. 10% of our class now are natives. We're doing some amazing things. But before we get into our panel discussion, I need to read our land acknowledgement statement. And first thing I want to say is we don't take this as a check mark. Myself, I went to 11 different council meetings between Pascua Yaqui and Tohono Nation as we worked on this statement. It says, we respectfully acknowledge that the University of Arizona is on the land and territories of indigenous peoples. Today, Arizona is home to 22 federally recognized tribes, with Tucson being home to the O'odham and the Yaqui. And this is a part I think really hits me is we are committed to diversity and inclusion. The university strives to build sustainable relationships with sovereign Native nations and indigenous communities through education offerings, partnerships, and community service. And this is an example of why we're here today. So with that, I'm going to turn it over for our very first panel. And I'm thrilled to have moderating. We have Heather Whiteman runs him, and then she'll do the introduction of our panelists, and we'll go from there. Thank you very much.
Morning. Ichik Daluam, as we say in my language. I'm Heather Whiteman Runsim of the Crow Nation in Montana. So I thank the Arizona tribal leader folks in the room and online for I guess their hospitality for those of us who are transplants to Arizona. Wanted to thank Miss Indian University of Arizona, or Miss Native UA, for her beautiful blessing at the beginning, and thank you, Levi, for the land acknowledgement. I am the director of the Tribal Justice Clinic at the University of Arizona Rogers College of Law under the Indigenous Peoples Law and Policy Program. And as director of the Tribal Justice Clinic, I teach a class in which our students are asked to work on real projects on behalf of real clients. Our focus is working on projects for tribal nations, for Indigenous peoples, for Indigenous organizations, individual Indians, and to work to promote tribal sovereignty or promote the well-being of Indigenous individuals. So I was very happy when Dean Massaro with the Haury program and the Office of Native American Tribal Affairs and Engagement asked me to help put together the program for today, because it's very in line with what we seek to do through the Tribal Justice Clinic. I want to acknowledge my students. If you guys would stand up. These are the Tribal Justice Clinic participants, the 2023-2024 academic year, and they're here to help you guys. They're here to be at your beck and call, folks who are attending, and help out however they can for the duration of the day. Thank you for being here. They're here a little earlier than their usual Wednesday morning class time, so we appreciate that. But yeah, thank you, folks. We are happy to put together a program that would serve tribal leaders in our region by providing information and an opportunity to engage with Supreme Court and subject matter experts on issues recently taken up by the United States Supreme Court. Having worked as in-house counsel for my own tribe and as outside, not outhouse counsel for many other tribes over my 2 decades of practice, these conversations can be incredibly important and informative. Having these opportunities to share perspectives and experience is beneficial to tribal leaders, and there is not always enough time for us to do that. And I think academics also always benefit from having more perspective and interaction with tribal leadership and folks from our communities in Indian country. The United States Supreme Court regularly issues decisions that have dramatic impacts on the lives of individual tribal citizens. Navigating these sometimes seismic shifts is a challenge for tribal leaders, whether we choose to be proactive or reactive, or if we have the luxury sometimes of disregarding what the Supreme Court says about our self-determination, our rights, the ongoing vitality of our treaties, and other critical issues to a daily life in Indian country. The Supreme Court's decisions do tend to stay with us for decades and sometimes centuries. Understanding the history behind, as well as the ongoing implications of the court's recently decided cases, identifying trends, and thinking and strategizing about lawmaking and governance to prevent cases with unfavorable facts from going before the court is really our overarching goal today and what we are seeking to support. To that end, we tried to balance access and participation in these conversations to a wider audience with our overarching goal of providing a more direct forum for those dealing with these issues on a daily basis on behalf of nations. So our first more general session with Supreme Court experts is available online, not just to tribal leaders, but to others as well. And the remainder of the day will be a smaller in-person audience of tribal leaders, tribal government officials, and their designees. So we're really thrilled to have the folks that are with us for our morning panel. Oh, and I also wanted to note that today is a very important and significant day to be having these conversations. It's the anniversary of the passage by the United Nations of the United Nations Declaration on the Rights of Indigenous Peoples. That happened today, I believe, 16 years ago. So with that auspicious anniversary in mind, I think these conversations take on even more significance. So I'll get on to our first panel. I want to introduce our panelists. We have with us today Professor Matthew Fletcher, who is the professor of law at the University of Michigan. He is the Harry Burns Hutchins Collegiate Professor of Law at Michigan Law, teaching and writing in the areas of federal Indian law, American Indian tribal law, Anishinaabe legal and political philosophy, constitutional law, federal courts, and legal ethics. He also sits as the Chief Justice of the Pokagon Band of Potawatomi Indians, the Porch Band of Creek Indians, and the Grand Traverse Band of Ottawa and Chippewa Indians. We also have with us today my former colleague at the Native American Rights Fund, Melody McCoy. She is the Native American Rights Fund staff attorney. Since 1986, Melody's practice areas have included jurisdiction in Indian country, tribal rights on education, tribal trust funds, and tribal intellectual property rights. She served on NARF's Litigation Management Committee from 1992 to 1995 and 2007 to 2019. She has been the lead NARF attorney since 2022 on the Tribal Supreme Court Project, a joint project of NARF and the National Congress of American Indians. Melody has practiced before all levels of tribal, state, and federal courts and has argued a case before the United States Supreme Court. Melody is a citizen of the Cherokee Nation. And we also have joining us online for this program, Professor Greg Ablowski. Professor Ablowski's scholarship focuses on early American legal history, particularly on issues of sovereignty, territory, and property in the early American West. His publications explore a range of topics, including the history of the Commerce Clause, the importance of Indian affairs in shaping the U.S. Constitution, and the balance of power between states and the federal government. His book, Federal Ground, Governing Property and Violence in the First U.S. Territories, was published in 2021 by Oxford University Press. His work has received the Cromwell Article Prize and the Catherine T. Pryor Prize from the American Society for Legal History. So welcome to our panelists. We're looking forward to hearing what you have to share with us today. I'm going to ask Ms. McCoy to begin our discussion.
Thank you, Heather. And thanks to everyone for the invite to this, the organizers, the sponsors, the Arizona tribes and other tribes, and certainly the students. Wado, as we say in Cherokee. So I've been at the helm of this Tribal Supreme Court project, which, as Heather mentioned, is a joint project of the Native American Rights Fund and the National Congress of American Indians for just over a year. So I came in at the end of the term with the current court, and then through this term, and now we're anticipating the opening of the courts next term in a few weeks. It's two things to say right out of the bat. I'm really grateful for the Tribal Supreme Court project, and to be able to be involved in that after its inception in 2001, and to try to lead it forward. I'm less enamored of the court as an institution or a entity for tribal interests. So, but the combination of the two, we're doing the best we can. And I think that the Tribal Supreme Court project has really found a role to help tribes, because we know we can't keep all cases out of the United States Supreme Court. Just looking at the last two terms that I had to deal with, some would say that the goal of the project, which was to improve the winning record or the win-loss record, because in the court there's typically a winner and a loser, and everything in between, had improved since the project was started back in 2001. So in the court's 2021 term, we had three major decisions: the Isleta del Sur, the Denespi, and then of course Castro Huerta. And some would say those were 2 wins for tribal interests and 1 big loss. In this most recent 2022 term, we again had 3 decisions, major decisions on Indian law, the Brackeen decision, and then the Arizona versus Navajo Nation decision, and then the Lac de Flambeau decision. And some would say that there was the Brackeen, of course, was a major victory. And then the other 2 were losses, one more narrow, so to speak, than the other in terms of votes, Arizona versus Navajo Nation. So the 2 terms that I've really been involved in, 2 wins, 1 big loss, latest term, 1 big win, 2 losses that, in my view, really didn't have to be losses. So I think at this point, my message to tribe leaders and their attorneys is beware. I am not, like I said, enamored of this court as one that is in any way likely to uphold tribal interests. Some would say that it's, and the court has been characterized as this before, as a chip away court. And I don't mean chip away in the tribal name sense of the word. I would call it, in some respects, a takeaway court. And I can elaborate on that more. I think it's really risky to ask this court to decide Indian law issues in a way that are going to be favorable. I know that Brackeen is an incredible shining star, and I am grateful for Brackeen. I think it exceeded everyone's expectations on the tribe side in terms of what it did. But I also think that it is not a good idea to think that any subsequent decisions from this court are going to, are likely to be on a par with Brackeen. So my advice to tribe leaders is to think long and hard before one asks the court to take a case, even if one has obviously not prevailed at the lower court level. And I also think that we need to really work hard to help tribes that are facing cases that might be ones the court will take, to keep those out of the court if at all possible. And if they are taken by the court, to work really, really, really hard to shape the case at the merits stage in the court. An example of that would be the Arizona versus Navajo Nation. So those are my initial thoughts. Beware and be resourceful. There are, in addition, there's the Tribal Supreme Court project, and I can go into more about what that entails, but it really consists of a voluntary group. Everything about the Tribal Supreme Court project is voluntary. No one has to use it, but it's there if one wants to use it. And it consists of a group of 300 voluntary attorneys, law professors, advocates, who really want to help tribes at the Supreme Court level. And it also consists of a good group of what there's called Supreme Court practitioners, because there is now a dedicated group of practitioners, attorneys and their law firms, mostly private, but also university, law school, Supreme Court clinics that are there. And they really do have a lot of expertise, not necessarily with Indian tribes and Indian law, but with the practice of the Supreme Court and in particular, experience with the Supreme Court. They either have clerked for the Supreme Court justices or they regularly practice before the United States Supreme Court. And I think in this day and age, tribes are remiss if they don't take advantage of that. There's more than just one Supreme Court practitioner out there, and it's really amazing to me how many are available and willing to help tribes. So again, I strongly urge tribes and their attorneys and the Tribal Supreme Court, you can do this on your own, but the Tribal Supreme Court Project can also help you hook up and identify appropriate Supreme Court counsel for your tribe, your case. I shall pause.
Okay. I guess that means I talk now, or all right. I'm Matthew Fletcher and a law professor. I started my career here in Tucson as in-house counsel for the Pasquayaki tribe. And that's generally my career, is working in-house for Indian tribes. I worked for 3 other tribes besides Pasqua, Hoopa, Suquamish, and Grand Traverse Band, my own tribe in Michigan. And that's sort of my practice perspective. So I'm the guy who will tell you, as in-house counsel, it's one of our roles is to represent and advise tribal government, tribal leadership on a wide variety of issues. One of those issues is federal and state court litigation, cases that could actually go to the Supreme Court. Decisions that the tribal council makes that seem innocuous in the moment may actually 5-10 years down the road become fodder for the Supreme Court. So I'm going to echo something that Melody said, and I'm going to tell you right now, if the worst thing that could possibly happen for most tribes is they have to go to the United States Supreme Court. It is not hospitable. They do not want to see you there. They do not like Indian tribes. There's a couple of them in there now that are supportive. They are historic anomalies. Those kinds of people have never been on the Supreme Court before. And it's amazing that there are 2 of them right now. But to counterbalance that, there are 2 of them that would throw all of federal Indian law from the very beginning out the window, disregard other treaties, destroy the power of Congress to enact laws that benefit tribal interests. So that leaves out of the 9, that leaves 5 in the middle that we have to try to persuade. But really, every single case is kind of like, can we get 3 out of those 5? And what I'm trying to highlight for you, in addition to the fact that this is the Supreme Court historically is a terrible place for tribal interests to be, that it's the way that you litigate in the Supreme Court is a game. You have to think of it as a game. So here, let me give you a little bit more of historical context in terms of wins and losses. We're thinking of it as a game. Since 2014, tribes have won 11, in my count, 11 out of 18 cases. So 11-7. That sounds pretty good. And it sounds okay. I mean, if you're trying to go 18 or no, but historically, that is the best that tribal interests have ever done for an extended period of time in the entire history of the United States Supreme Court. Now think about that. Prior to 2014, there were dozens of law review articles, some of them are mine, basically lamenting the fact that tribes have a worse win rate in the Supreme Court than convicted criminals pretty regularly. People who are in jail for murder do better in the Supreme Court than Indian tribes do. And that is a consequence of so many different things I want to get into. I don't want to get too law professor-y on you. So that's one thing. The other thing I want to talk to tribal leaders is about is if you do end up in a case that you think is going to go, that maybe your attorneys think is going to go to the Supreme Court, you have to start thinking about strategy at a very early time. Don't wait until you get to the Supreme Court. There are a lot of pressures that tribal leaders, tribal attorneys will see. You are going to be inundated probably if you have a case with outside counsel. I won't call them outhouse counsel. That's not accurate, but outside counsel, many of whom come from effectively for-profit law firms. They want to go to the Supreme Court and they really, I mean, they want to win. Nobody really wants to lose a big case in the federal courts, but they get paid whether they win or lose or not. So always keep that in mind. Whenever you are thinking about whether a case is going to the Supreme Court, listen to somebody like Melody. Melody doesn't make more money because she is working on a case that went to the Supreme Court. Find somebody objectively who will tell you, who doesn't have a proprietary or pecuniary interest in the outcome of whether or not you move forward with a case, get somebody to tell you whether or not this is a real thing that you should talk to. Melody is really, and the rest of the people at NARF that work on the Supreme Court project really should be your somebody you should talk to, just to do your due diligence. Years ago, I wrote a law review article. I volunteered to do that facetiously. I called it the Clinic of No. And I said, if you make me your lawyer, well, how much money do you have to get to retain a lawyer? Give me $100 and I will tell you, I'll write you a memorandum, attorney-client privilege. Nobody ever has to see it, why you will lose in the Supreme Court. There's no case that's a guaranteed win. And when you're in the Supreme Court, even though we have a pretty decent win record for the past decade or so, you're actually not, you're not going to win. I could tell you every single case is a close case. Even the ones that go like 8-1 or 9-0, those are really close cases. And the ways and the traps that you can lose those cases are many and varied. So I don't know what else to say. I mean, I could talk more about the details about how this works. And I would like to talk a little bit about, I guess, the cases. The last 2 terms are really important. I said we won 11 out of the last 18 cases. I think that's about to turn. And the last 2 terms are really good examples of that. So there are 2 big themes as a substantive matter that I think the Supreme Court can be counted on at this point. We know some things because of the last decade, because of what the Supreme Court looks like, who's on the court, who appointed the people who are on the court, that sort of things. One thing we really know for sure is that federal supremacy in Indian law is really supreme. The Supreme Court of the United States has always sort of paid lip service throughout the history of federal Indian law, not just lip service, but given teeth to the powers of Congress to pass laws in Indian affairs, the powers of the executive branch, the Department of the Interior, the Department of Justice, and other federal agencies to do as they wished in federal Indian law. And for the first 100, almost 200 years of the United States into the 1970s, that almost always was negative toward tribal interests. So when the Supreme Court was affirming the powers of Congress and the discretion of the federal agencies up until the 1970s, what they were doing was voting almost always against tribes. So those lengthy precedents, historical precedents of respecting the powers of Congress and the discretion of the federal agencies remains extant, mostly. Because since the 1970s, as many of you know, we've entered the self-determination era. Indian people run the Bureau of Indian Affairs now. There are members of Congress who are actually Native and actually have some power, a little bit. Congress generally passes laws that favor tribal interests. Congress passes laws all the time that say things like, we think the trust responsibility is a real thing and that it's enforceable. But there are also federal agencies that are not really so hospitable to tribal interests. And the big one that can be potentially a very large problem is the Department of Justice. Not so much the Department of Interior, although sub-agencies within Interior can give us trouble. But the Department of Justice decides when a case goes high up into the federal courts, especially at the Supreme Court, what the position of the United States is. The president doesn't really tell the Department of Justice what to do. The Attorney General doesn't really tell the Department of Justice what to do. It's kind of like a small group of lawyers called the Office of Solicitor General that decides the position of the United States. And they're not accountable to anybody in any really meaningful way, and especially in Indian law cases, okay? Nobody tells them what to do. So if Interior says, we're your client, you represent us, Department of Justice, we want you to argue a position in favor of tribal interests. Department of Justice might have another agency saying, well, we think the opposite. They're always going to pick the other one. That's almost always the case. Justice is not on our side unless they absolutely have to be. And by the way, if you sue the United States, by definition, you're going to be on opposition to the Department of Justice. And always remember, the Department of Justice is the largest, most powerful law firm in the world, without a doubt. So they're powerful. So that's the second substantive thing we need to talk about, and then I'll sort of stop. I'm happy to answer questions, and I know Greg is going to say some things too, is the way the Supreme Court decides cases. I already gave you a sense that there's 2 judges that we can generally say are going to be on our side, and there's 2 judges that we pretty much can say are always never going to be on our side. But what those most of the court does is makes decisions based on what they refer to as textualism. Now, what is textualism? That means Congress passed a law and you can write it down and see the words, or there's an Indian treaty, you can look at it, there are words to it. Lawyers love words. When things are reduced to writing, that's our bread and butter. But when somebody says, hey, apply these, the trust responsibility, what is that? I mean, it's not necessarily written down in a way that lawyers can quickly understand, especially if they don't do Indian law all the time. Or, I don't know, the inherent powers of Indian tribes. What is that? Nobody really knows. So if you don't have the words written down in an actual law, like an act of Congress, a treaty, an executive order, a regulation, if you don't have that, then the Supreme Court literally thinks of itself as free of the shackles of textualism. But if you have language before them in an actual law that is passed by Congress or adopted as ratified by the Senate as a treaty or whatnot, they're stuck. That's textualism. They're stuck with the words of that text. And all of the interpretive rules of textualism favor tribes, every single one of them. We should win all of the textualism cases. Almost all the time, we should win those cases. And if we don't, that means they had to really do some legal gymnastics to get out of that way. And here's a couple of things of what we know about how the Supreme Court decides cases under a rubric of textualism. One, if there's no text, they could do whatever they want. They're just straight up politicians. And that does not favor tribal interests right now. 6 Republican appointees. No offense to any Republicans out there, but they do not vote for tribal interests hardly at all. And if there is a text, it's got to be pretty strong, and it probably will be in favor of tribal interests. And if there is some big really big federal program that the Supreme Court wants to support, then they'll throw all of those things out, all the textualism out in favor of that federal program. And we saw that, just one hint of that this last term with bankruptcy. Here's a little secret about bankruptcy. There are X number of federal judges, and that they don't handle bankruptcy cases. Bankruptcy is generally federalized. There are 4X federal bankruptcy judges. And what thing that the federal judges do not want is to handle bankruptcy cases. There are special judges just for them. And the last thing the Supreme Court wanted was to mess with that system. Tribal sovereignty in this last term, in this case called Lac de Flambeau versus Coughlin, was about to mess with the Bankruptcy Act. And so the Supreme Court said, all of the rules of default interpretive rules of Indian law favor the tribe, but we can't have that because of bankruptcy, the policy of bankruptcy. All of this is an example of how if the court gets 5 votes, they can do anything at all they want to, absolutely anything. Nothing prohibits them from discarding all of their rules and principles and precedents in favor of a policy as politicians that they choose to promote. And that's a really big reason why we tend to lose those cases in the Supreme Court. And when we do win, it's almost always because of textualism, because the court looks at the treaty and says, yeah, the treaty says this, we can't rewrite the treaty. Or an act of Congress says, yeah, Congress said this. We hate it personally as humans and politicians, but I mean, what are you going to do? Congress said it. That's what they did with the Indian Child Welfare Act in Howland versus Brackeen. There's nothing they could do about it. They want desperately to throw that out. Most of the court does, but they can't at this point. So I'll stop right there. Too much law professoring. Turn it over to another law professor.
Go ahead, Professor Blavsky.
Great. Well, thanks very much. Hopefully you can hear me. And thanks so much for the invitation to speak. I'm sorry I couldn't be there in person. I have a 2-month-old at home, so I'm busy being a new dad. You may hear her in the background occasionally. My apologies. So let me just, paralleling Matthew, let me talk a little bit about how I got into this, which is a little differently. So I'm a legal historian. I was trained as a legal historian. I spent a lot of years seeing the legal history of the early American founding. And, one of the questions you get as a legal historian, and actually I got at one of the very first Indian law conferences that I was at, that Matthew was at, was sort of, well, so what? Who cares about legal history? Like, this is all very interesting, but, what is the relevance? Well, I think it's pretty clear now that we are in a period where legal history is dangerously relevant because the court at least pays lip service to the idea through originalism, through textualism, through these other isms, that the meaning of the words at the moment that they were enacted is going to be dispositive in the case. And so the last couple terms, I've been heavily involved in writing amicus briefs because of the historical work that I have been doing. So I wrote briefs, helped write briefs in Dinespi, in Castro Huerta, most notably in Burkina, and then I was involved in talking a bit with Supreme Court practitioners in a number of the other cases as well. So I think what I want to focus my remarks on is sort of what is different about the court right now for tribes as opposed to, the court maybe a decade or two ago. Because, as both Matthew and Melody pointed out, right, like the court has not been a hospitable place for tribes for quite a while. It has been the Chippewa court for a very long time. So what is different about these last couple terms in federal Indian law, and what should tribes be looking out for if they are litigating in front of this court? So I think one of the things that is clear to anyone who's paid attention to the court over the last couple terms is that they are making big changes and thinking very broadly and don't feel particularly constrained by the precedent. And obviously, right, this is not just in federal Indian law. This is in abortion. This is in gun rights. This is much more sweeping, that the court is acting extremely aggressively. And I think what's going on is we are seeing that carry over into federal Indian law as well. That, when you have these decisions in the past, terrible decisions like, Plains Commerce or something like that, Plains Commerce didn't really claim to be making a bunch of new law. Plains Commerce ostensibly paid fealty to the prior principles of law. If you look at the big cases that the court is deciding now, if you look at Castro Huerta, if you look at Burkina, these are cases where the court is grappling with big issues and issuing very sweeping decisions, decisions that purport to assert sort of re-examine and foundational principles of federal Indian law and assert new ones. And so I think more than, at least for the past 20 years or so, some of the big questions in federal Indian law are up for grabs. And that's a really dangerous moment, I think. And I think Castro Huerta and Burkina both embody this challenge. And I agree with both Matthew and Melody that I don't think we should take too much hope from Burkina. I think in some ways Castro Huerta represents the trend line of where this court is going to head in federal Indian law. So what does this mean? I think that the key thing to point out is that this court has a distinctive perspective, right? I mean, all the justices all have their own distinctive perspective, but as Matthew noted, we have the triumph of textualism and as interpretive methodologies. And so what that means, I think, is that the foundationals that people in the field have long relied on don't necessarily carry a ton of weight with this court. So going into this court, and as we saw, right, with the Navajo Nation decision and sort of emphasizing the trust responsibility or other ideas that tribal leaders know are deeply rooted in the history and decisions of the Supreme Court, those arguments, I think, are going to carry less weight with this current court. Because this court, as Matthew pointed out, is going to say, show me the text, right? Where in the text of the Constitution do you see the words trust responsibility? And so I think what Indian law advocates and tribal advocates are going to have to do is they're going to have to come up with ways to pitch Indian law arguments that are framed within these dominant jurisprudential approaches. That means sort of thinking very carefully about how to pitch these cases as textualist cases. And I think Matthew's right. If you look at it sort of at first blush, it seems like textualism often is going to favor tribes. But I think Castro Huerta is an excellent example of how tricky textualism can be in practice. Because what was striking about Castro Huerta was you have this federal statute from 1834, actually a precursor of it goes back to 1790. The widespread assumption had been that this precludes state jurisdiction over crimes committed by non-Indians against Indians in Indian country. But the court said, well, show me where it says that in the text. where in the text of the statute do you literally see those words? And of course, those words do not actually apply, do not actually literally appear in the language of the text. It only becomes abundantly clear what Congress meant when you look at it in the historical context. So what does that mean? I think what it means is a couple things. I think one, I think people working in Indian law are going to have to think about building alliances with people in the legal academy more generally to think about how to pitch these cases, not just in sort of familiar terms of foundational federal Indian law principles, but to think about how to pitch this in terms of the dominant paradigms of originalism, textualism, so that it will appeal to these justices. Now, that doesn't mean necessarily that it's going to be a winning argument, right? As Matthew pointed out, the justices can do what they want. But I do think pitching it in the terms that are legible to them, it makes it harder for them to disregard those arguments, right? That it makes it harder for them to sort of sweep aside these arguments. And so I think it's really important that people working in federal Indian law build conversations with people focused on Supreme Court litigation more generally, and think about particularly how to grapple with these sort of dominant approaches to law and how to pitch the argument. Because, you know, one of the things that's striking when I talk to my colleagues who are sophisticated Supreme Court litigants, they know exactly which justice thinks about the law in which way, and they build the arguments to cater to those particular justices. And so we have to do that when we are litigating these cases in federal Indian law as well. We have to be mindful, not just of how do we appeal to, you know, the court as a whole, but we have to think about what arguments are going to carry weight with which particular justice. So I think that's really important. The other thing is just I reiterate the points about caution. I think the real danger in the coming years is we're going to see some very sweeping decisions like Castro Huerta that sort of throw out foundational principles of federal Indian law and purport to assert new principles that make it very difficult for tribes. So I think one of the consequences of Castro Huerta is that it puts a huge thumb on the scale for state power and jurisdiction in any conflict between state and tribal interests. So, you know, I think fights over a BRCA case, a fight over taxation, state taxation in Indian country, is going to be very difficult to win in front of this court in the wake of Castro Huerta. I mean, the language, the decision has some very broad language about how under the 10th Amendment, state jurisdiction is the norm within Indian country. Now, that I don't think is an accurate statement of prior precedents. It's not an accurate statement of the history. But nonetheless, I think what we're going to see is that language get weaponized and used by people on the other side. I think one of the things that's striking to me about Brackeen and Castro Huerta is that we are seeing sort of the development of a better organized conservative bar interested in pushing back on some of the foundational principles of tribal sovereignty and jurisdiction. And I think with this court, they have really a perhaps unprecedented opportunity to reevaluate some of those foundational questions. So, you know, I think we're going to see more fights like Castro Huerta, and I worry that we're going to see more votes along the lines of Castro Huerta in the future. And so I think it's going to be a hard fight down the line to try to prevent more decisions. And even more than the literal outcome of Castro Huerta, I'm very scared about the sort of broad language and reasoning that Justice Kavanaugh employed in that opinion becoming the norm in these areas, because I think the decisions like that can be a wrecking ball for whole areas of precedent that we thought were very well established, but you know, in this court might fare as well as other areas of precedent that we thought were very well established as well. So I'll stop there as well. But that's my sense of where we stand with federal Indian law in this court.
Great. Thank you to each of the panelists for those introductory reflections. I wanted to let folks know online that the question and answer function of your webinar is open. So if you have questions you want to present, we'll try to get to those as much as we can. But right now I wanted to open it up to questions from the folks here in the room. If any of our participants have any questions that you're dying to ask these esteemed panelists right now. If not, I have a few as well, but this is really for you all, not for me. Anybody have questions? Do we have any questions coming in online yet? No? Okay, yes,
Oh,
we're getting a mic over to
Yeah.
you to,
the question, she asked me the question, who are the two in favor on the Supreme Court and two against? Well, the two against are easy. It's Samuel Alito and Clarence Thomas. And Clarence Thomas for a couple of decades now, really since 2004, in pretty much every Indian law case that he's not writing the majority opinion, writes separately to disparage everything about Indian law, far afield. And he thinks we should throw all of the precedents out, throw all the treaties, all the statutes out and start from scratch. And he's pretty clear on what he means by that. He means Indian tribes are not sovereign. States have total plenary control over tribal governments who are not sovereign. Treaty rights are irrelevant. They're old and dead, and we shouldn't think about them anymore. Samuel Alito is, and I'm very comfortable saying this, probably one of the worst racists to ever sit on the United States Supreme Court. And I'm talking about justices who were from the South before the Civil War. He's right up there. He's a little bit more careful and circumspect about it, but not much. So those are the two against. The two in favor are Sonia Sotomayor, who I give 100% full credit to for the sort of this renaissance for tribal interests in the Supreme Court. I really think she is the first Supreme Court justice in history to take federal Indian law seriously. She reads law review articles. She reads the amicus briefs filed by tribes and law professors like Greg Oblavsky. She takes them seriously and she incorporates them and puts them into written opinions that often in dissent, especially at the beginning of her tenure on the Supreme Court, but required the rest of the judges to become intellectually honest about what they were saying and doing in a way that never happened before. And then the second who is in favor of tribal interests, still baffling to me, is Gorsuch. And Gorsuch has gotten to the point where I'm a little afraid when he writes opinions. They are so positively in favor of tribal interests. They read like, a radical Matthew Fletcher writing law review articles, always saying tribes should win every case. The problem with Gorsuch, I suspect, and I don't know anything about what's going on, is he's not really a consensus builder. So if you disagree with him, he points out how you're wrong. And he doesn't try to like compromise, I don't think. Maybe Sotomayor is that little way too. But that leaves the rest of the court in the middle. And, we have Elena Kagan, I think, is a pretty solid judge for tribal interests, not always. KBJ, Justice Jackson, who is the first African-American woman on the Supreme Court, has only been on there one term. I think she's absolutely amazing. But then the rest of the court, the other three are all very conservative judges. So you always go into the court thinking at best you're 5-4 against if you're a tribal interest when you go in.
any questions to follow up on that? Yes. Is this
We've just got a couple of questions online.
great?
Right. Can you please comment on the Maverick Gaming case and its relationship to equal protection and the racialization of Native people? Do you see Maverick going to the Supreme Court?
Great. So does someone want to give us a little bit of background on what the Maverick case is?
Sure, I can do that if you know. Yeah. So Maverick Gaming is a non-Indian, actually it's a tribal member, I think, but it's a non-tribal gaming entity in Washington State. And they are sort of shut out of a certain kind of gaming that tribes are allowed to do. So the thinking is that tribes have a certain kind of monopoly over type of gaming by virtue of the fact they're tribes. And all others are excluded in Washington State from this kind of gaming. So we have the Indian Gaming Regulatory Act. There's a lot of historical examples of tribes having sort of this exceptionalism, both positive and negative. So tribes up until the 1970s were targeted by Congress for things like termination and allotment and assimilation and boarding schools and all these terrible things. And the Supreme Court looked the other way because it's like Indian law is exceptional. But that's shifted in the last half century. Now Congress tends to favor tribal interests. And the Supreme Court and the federal judiciary are looking very carefully at that. And the opponents to acts of Congress and decisions by state governments that favor tribal interests are claiming that the reason that tribes are now favored by legislatures is race discrimination. So the the argument that Maverick Gaming is making is that the Washington State Legislature and the National Indian Gaming Commission, which is a federal agency, have approved of a kind of gaming monopoly favoring tribes that discriminates against non-Indians, non-tribal entities. And they're trying to say that it violates the equal protection principles of the United States Constitution, which exists in two places. The 14th Amendment says that states shall not abrogate, shall guarantee equal protection of the laws to all persons. And the Fifth Amendment of the Constitution doesn't say equal protection, but there's a due process clause in there that the Supreme Court says applies to the federal government. So the thinking is that Maverick Gaming is trying to make the argument that when tribes get this monopoly, it's because of race, and it violates the equal protection principles of the Constitution. The problem with that argument is the long line of precedents, some of which say tribes and individual Indians are disfavored by Congress, and some say they are favored by Congress, are all outside of this normal rubric of the equal protection principle. And the rule comes from a case called Morton versus Mancarry, that if Congress or a state government passes a law that is rationally related to the fulfillment of the trust responsibility, then it is constitutional, full stop. That is the end of the discussion. You don't go into whether or not it's race-based discrimination or any of that stuff. It's just fundamentally outside of that question. The core attack on the Indian Child Welfare Act was an attack under the equal protection principle. And the Supreme Court in Holland v. Burkeen punted on that case. But the opponents to tribal sovereignty and to the powers of Congress and state legislatures to deal with Indian tribes are trying to use any vehicle they can to get the Supreme Court to say that the rule of Morton versus Mancarry either is weakened or is not relevant, or just overrule it altogether. So they try to do that with the Indian Child Welfare Act, and so far have failed. Now they're trying through this gaming case, Maverick Gaming. The case right now, this is Maverick Gaming, and my prediction is probably not likely to do much of anything for a few years, because the Maverick Gaming is going to lose in the Ninth Circuit. This case is in Washington State, which is in the Ninth Circuit federal courts. And the precedents there are absolutely clear that tribes and the federal government should win this case. But when the real interesting thing will happen is that Maverick Gaming is going to file a petition for the Supreme Court to hear the case. And the petition is basically going to be, the Ninth Circuit is wrong in all of its laws. Other circuits disagree with some things about the Ninth Circuit. Fix it for us. And that's how Brackeen got to the Supreme Court. That's how some of these Indian law cases get to the Supreme Court. Not that they're wrongly decided, because they're following the precedents. It's that opponents are saying the precedents are wrong, and they think that there are enough votes currently on the Supreme Court to throw all of that stuff out of the bathtub. And the chances of that happening are pretty good, unfortunately.
Can I jump in very quickly here? I think I'm slightly optimistic, and I'm usually not optimistic, but I am slightly optimistic in the wake of Burkeen on the equal protection question. And I know we're going to have more discussion of Burkeen later on today, but I think the opponents, tribal opponents, can count as well as we can. And if you look at Burkeen, I think it is at least heartening that there's only 3 justices. So we have the 2 justices, Alito and Thomas in dissent, and only Justice Kavanaugh sort of writes separately to signal his support for the equal protection argument. I think if we're counting noses, the conservatives would have to peel off either Barrett or Roberts, or actually both of them, in order to sign on to this equal protection argument. I'm honestly slightly optimistic in the wake of Burkeen that it's going to be very difficult for them to do so, right? That if you count the noses in the wake of Burkeen, it doesn't seem like this court has an appetite for taking up the equal protection argument. I could be proved wrong. I'm rarely optimistic about these things, but I do have some glimmer of hope that only Justice Kavanaugh felt the need to sort of write this, what some have called a cavcurrence, in which he sort of suggests, actually, I really think there's equal protection qualms about this. I do think the fact that we start from a base of 4 on this question is very helpful, as opposed to starting from a base of 3. So we'll see what the court does with these equal protection challenges. But my suspicion is that, having just dealt with this in Burkeen, they will not take this up again for quite a while. I hope I'm right. I'm worried I'm not.
Melody, did you have anything to add on those points?
Well, the Maverick Gaming case is one we've been watching for sure. It's, again, as they've said, it's kind of one of these deliberately targeted attacks, and it's backed by the same groups that brought the Brackeen target. You know, my sense is that you know, a lot of these, they say they're, I mean, it's kind of a twinfold thing. I mean, obviously in Brackeen, there were for-profit private adoption agencies that claimed that they were being economically harmed by principles of Indian law that stand for tribal sovereignty and as opposed to race. And same thing in Maverick Gaming. You know, they claim they're being economically disadvantaged. I think it was mentioned earlier that I work for a nonprofit organization, so I'm aware of what for-profit means, and I nobody wants to be poor, and I'm not rich, and so I understand the economic forces at play here, and that's about it. But I also think that it echoes kind of what was said before too. I mean, in this instance, you know, you get people fired up to say that I'm being discriminated against because I'm not Indian. And I have a hard time with that based on what I know about history. I'm obviously not pro-discrimination. I'm not trying to say that it's right, but in the context of tribes, there's a different paradigm and a different way of looking at it. And what is at risk is that, as we've said, is that paradigm is dismantled so that there is no more tribal sovereignty. There is no more political intergovernmental relationship between tribes as sovereigns and the federal government and yes, the states. And it becomes simply a matter of what can be characterized as discrimination based on race. To get to that result, I am wary because this court, as we've said, is very result oriented. And my sense is that this court can and will do what it can do to reach the result it wants. Whether there's sufficient votes to even take the case is something that the professors have debated. And I appreciate that. But I am concerned that the current composition of the court, there's enough unconstrained and unaccountable individuals on the court that it does make me very nervous. And again, the fact that the United States would be involved because of the Indian Gaming Regulatory Act, like the Indian Child Welfare Act, is a little bit of comfort. I think it's been a while since we've seen a United States Congress that's functional enough to strongly state tribal interests. But for example, in the case of the Indian Child Welfare Act, which is truly one of the most far-reaching statements of Congress about tribal sovereignty, in addition to NAGPRA, because of course it allows tribal sovereignty to go beyond the boundaries of tribal territory. So that in the Indian Child Welfare Act, if you have an Indian child anywhere, tribal sovereignty comes into play. Same thing with the Native American Graves Protection. It's not territorial based. I'm not as familiar with the underpinnings of the Indian Gaming Regulatory Act. I know it was a controversial act that was actually passed over tribal opposition. So I'm not quite sure how the United States is going to fashion its arguments based on the Indian Gaming Regulatory Act, as opposed to the Indian Child Welfare Act, which had a solid base that, as Professor Fletcher said, the court was just unable to dismiss. And the Indian Gaming Regulatory Act then, in a way, calls in the states in a way that the Indian Child Welfare Act did not. So it's a little bit different mix there as how the states, some of whom I think might do well to realize, unlike the Indian Child Welfare Act, that they as states benefit quite well from Indian gaming. So I think this would be a more interesting, I realize that in the Indian Child Welfare Act, the vast majority of states that weighed in with the court actually supported the Indian Child Welfare Act. And I don't know enough about the states that are so-called gaming states with Indian tribes and how that's going to shake out. But I think that actually might be an interesting thing to consider should this go up. The case that's a little bit ahead of this is the West Flagler case, and that's in the U.S. Court of Appeals for the D.C. Circuit. And they just, I think yesterday, denied rehearing, and it was a 2-to-1 panel decision in favor of the United States and the Seminole Tribe of Florida on the issues in that case. But it's the same group that is involved in the Maverick gaming case that's also backing the attack on the gaming compacts in Florida. So that case is a little bit ahead. So I expect we'll see within the time that's now running, since rehearing has been denied, a petition for certiorari in the West Flagler case first. And again, that to me is going to give a glimmer of how the United States and how the states, let alone the tribes, the Seminole Tribe of Florida in the West Flagler case, are going to fashion these arguments to this court. So that should be of interest.
Great. Well, Melody, you've touched on a topic that I think we could maybe spend a little bit more time on, and that's the role of state governments and state sovereigns in relation to questions about tribal sovereignty and tribal rights. And, you know, when we look at some of the most recent problematic opinions, Castro Huerta, Navajo Nation, we see the potential for maybe some unintended negative impacts on rights and resources of state government. So I'm wondering, you know, as we watch the sort of the impacts of some of these decisions on the ground, where we see state governments going. I think it used to be more typical to see more broadly crafted state amici coming in to oppose tribal sovereignty in a lot of these cases. And maybe we're not seeing that as pervasively now. But how do we see the positions of states maybe evolving over time to hopefully support tribes? And also, how do some of these opinions potentially have negative and probably unintended impacts on state sovereignty and the resources and administrative functions of state governments?
Well, I'm glad I brought up that excellent question. Professor Fletcher, what do you, no, just, I mean, you know, there's 50 states and not all of them have federally recognized tribes within their borders. It's not something I've thought about in depth, but it certainly is something to watch. For example, it's recently come up, I think, you know, in the wake of the Arizona versus Navajo Nation decision. What are the opportunities for the United States Congress to address some of the questions, issues about the federal trust responsibility to tribes? One of the suggestions, I was in a brainstorming group with folks, and they were saying that, you know, what one would need is kind of the equivalent of what happened with the Trust Reform Act of 1994. So the law that after well over a full century finally said, gee, United States Interior and Treasury, you are the trustee for tribal trust funds and the resources, the trust resources, timber, oil and gas, sand and gravel, rights of way that you manage as trustee. And you really haven't, and you really, as trustee, should provide these tribes with an accounting of your trust funds and resources. And I know the Trust Reform Act was, as most federal or any legislation is, kind of a compromise. It didn't give everything that either side or in either, I hate the word stakeholder, but the stakeholders wanted. So it was a compromise legislation, but it did say you had to provide an accounting, right? And of course, it was within 2 years of 1994 that the Cobell lawsuit was filed because there was no accounting to the individual Indian money beneficiaries in that. So anyways, what some people were saying is that we need that, an equivalent of that in the water rights context, right? Wouldn't it be great in an ideal world, if there is one, that if Congress were to pass legislation saying, hey, United States, you really are the trustee for tribal water rights. And if you could just, provide not the quantification itself, but the plan for addressing these, as Navajo Nation was seeking in the case where you said they don't have a substantive right to judicial review for that. If Congress could do that. Well, the Senate Committee on Indian Affairs, I think it's the Senate, is going to hold a hearing later this month on this. So maybe this will generate something towards that. But the point is, as we were brainstorming about this, and I think I was the only one in this particular group that was familiar with the Trust Reform Act and the ensuing multiple tribal historical breach of trust cases and the Cobell case. And I said, well, the difference is, okay, in the trust fund case, I mean, that's somewhat easy to say that, okay, United States, you are the self-imposed trustee for tribal trust funds, both monetary and resource-based. Okay, you need to provide an accounting, and so be it. And they couldn't or wouldn't do that, and that's why the Cobell case was filed and multiple other tribal cases, and we never saw really the court deal with those other than in like Hickory or Tohono O'odham on discrete issues because of the Obama administration's choice to politically settle those cases. The difference to me in the tribal water rights area is that I said, first of all, they're states, right? I mean, states are not involved so much in the trust funds that the government was managing. States are involved in water rights, and I'm not a water rights attorney, but I understand that states have an incredible interest in water rights. So that's going to be different. I don't know what states would say if the United States Congress proposes to have some kind of legislation that comes up with the so-called affirmative trust duty for tribes. Okay, so that's one to watch for sure. And the other thing is, of course, private interests. Now, I understand, in the trust fund and resource context, there are multiple private parties that have, timber contracts and oil and gas leases and things like that. But it's not quite the same as private water users. So that's another thing in the mix there that to me distinguishes this. So I think, we're starting to think of these things. Some people would say if Congress were to pass legislation that provided an affirmative duty, then we could get the judicial review from the courts, at least for declaratory and injunctive relief on that. But that's the first thing about states. So my point is that I think it's different. I mean, states to me, definitely in the water area are going to have different interests than states in the law enforcement area in the wake of Castro Huerta. Okay. And I don't know exactly what the differences are, but they're maybe very different. And I think, again, law enforcement to me may be more like Brackeen, where it's people. It's people. It's not a non-renewable resource. I think, one of the things I've noted in the decades I've been in Indian law is that, there's far more cooperation now between tribes and non-tribal governments, whether it's states or their political subdivisions in so many areas, taxing. But there's still fights. Okay, but there's a lot more cooperation. I think there's a lot more cooperation in law enforcement than there has been. And I think that's good. I'm not, again, pro or anti law enforcement. I'm pro public safety. And in these days when we have active shooters and multiple weapons everywhere, I think public safety has to happen. I was at the University of Wyoming Law School last week for their annual state bar and judicial conference, and there were a lot of judges, and it was interesting to me. I'd never been to that conference, but it was a very good conference. But one of my messages there, because I was asked to speak about Castro Huerta, was this issue of law enforcement. And of course, to some extent, Wyoming is a little bit different. It's one state with one reservation and two tribal governments. And it's not like Arizona or Oklahoma, where there's multiple tribes and reservations, et cetera, or California or Washington or Montana. But anyways, one of my points was that, and this follows up to the Supreme Court thing, I really, really think tribe leaders, it's incumbent on them at this point to really try to work some of these things out at the local level, because the risk of taking these to the court is so great, and you're not going to like it. You're not going to like the result. It's either going to be a loss or it's going to be a compromise win. So if you do it on your own terms, I mean, the essence of tribal sovereignty is to make your own decisions and to make good decisions. And so tribe leaders, I know it's hard. I don't envy the situation that you're in. And I know you're up against incredible other pressures, but do what you can to try to work it out, because if you don't, on your own terms, it's going to be done externally, and you're really not going to like it.
Thanks, Melody. Greg or Matthew, I wanted to give either of you a chance to chime in here too.
I'll just add very quickly, I think we're seeing a move away from states especially in the Supreme Court. This is not really necessarily about states always sort of pursuing what the best interest of their constituents would be. I think what we're seeing is there's not one set of entities of states that have a view. It's instead, we see the same sort of partisan networks. And so I think you saw both in Castro Huerta and in Brackeen, sort of, people lining up on either side of the V based on their political views, including state governments, right? So, Texas invited other states to participate in its litigation in Brackeen. It didn't get a ton of take up, but it got some other sort of conservative red state attorney generals to sign on. And I think we're going to see, and Castro Huerta was the same sort of thing, right? Where you had Oklahoma getting other red state attorneys general to sign on. Some red states with large Native communities have not been as eager to embrace this. I don't think like Utah, if I remember correctly, or Arizona have fully embraced these positions, but there are going to be entrepreneurial attorneys general in states like Texas, in the other states that signed on. I think Louisiana and Indiana were involved with the Brackeen litigation. So I think you're going to see more of that. I think what you're going to see is competing state views filing, amicus briefs on both sides of the V. And I think what that is going to mean is, the court is going to sort of rule generically for quote unquote states. But really what's going on is a partisan fight where both sides are sort of laying claim to the mantle of state sovereignty. So I feel like I would be skeptical of the idea that there is going to be a single state position. Instead, I think this is going to be heavily shaped by the sort of partisan litigation networks that guide so much of high stakes litigation in front of the Supreme Court right now.
I think if you're a tribal leader, this comes down to whether you're in financial or commercial competition with a state government. So that's where all the conflicts are. State governments also, like Melody said, they want public safety. So state and local governments, not always, they tend to want to cooperate with tribal governments. Our police are the same as their police. They go to the police academy together. So they're going to do the same thing. So if you find yourself in competition with a state government and you're a tribal leader, do everything you can to reach some sort of agreement with them in advance of all of this. In Michigan, we did a tax agreement. 11 of the 12 tribes signed on. The 12th tribe has been litigating against the state of Michigan over all the taxes that we've agreed on for 2 decades. They've lost every single one of those cases. It's just a tribe that refuses to sign a tax agreement with the state of Michigan. Now, there are state leaders like that too. Oklahoma and Texas right now, the attorney general and governor of both states would love to do everything they can to harm tribes. They're totally irrational actors. So what this means is if you get to the point where you have high stakes litigation that possibly can go to the Supreme Court, the Maverick case, Brecking, those cases, you end up seeing states tending to side with tribes. And the reason is that the Indian Child Welfare Act and the Indian Gaming Regulatory Act require states and tribes to negotiate and reach agreements. So Washington is on the side of the tribes in Maverick. Florida is on the side of the tribes in the West Flagler case. And so is the federal government. And that's the best place to be. And if you find yourself in opposition to a state over a dumb tax and you get to the Supreme Court, you're going to lose because they only look at the United States Constitution. And that says states have all these powers, federal government has all these powers. It's silent as to tribes. That's the only thing that matters to them. Tribes are going to lose those cases. So if there is a lineup of amicus briefs in a case, maybe under the Indian Gaming Regulatory Act, there's going to be some states that are irrational actors that I think recently they've been butthurt. Oklahoma and Texas lost cases against Indian tribes in the Supreme Court, and it cost people politically. So they're going to do everything they can irrationally to harm those tribes that harmed them. And that's going to happen for a while. And I think you're always going to have that situation. But you're also going to have lots of other states, including really deep red states. Oklahoma has an Indian Child Welfare Act that's adopted. Nebraska has one. Iowa has one. These are deep red states. I know people don't think Iowa is, but it totally is. And they've reached agreements with tribal governments on Indian child welfare. And they want to cooperate with those governments. You want to be in that position rather in opposition to states. You want them on your side. Do everything you can to get in that position. That's how you win a case at the Supreme Court.
Great, thanks. And I think we have a question in the back of the room.
Yeah. Just following up on red, blue states and all that. How does Public Law 280 states come into play on this?
Specifically in the context of law enforcement or on other issues?
No, not law enforcement. Not law enforcement, but because I'm familiar with it in law enforcement, how it's a challenge. I know, like my tribe's in California, right? We know Washington. You already mentioned the Maverick case. I mean, is it a different environment with those states when you're dealing with some of the things that we're talking about today outside of law enforcement?
Let me just throw something out. I really don't think Public Law 280 matters all that much anymore. Keep in mind, when it was passed in the 50s, the only state that really wanted it was California. The other states Nebraska didn't even want it. They just got it dumped on them because their congressional delegations like, yeah, us too. They didn't even think about what that would mean. But it does matter, I think, at a very local level, right? California is a very blue state. But if you go to Riverside County, you're no longer in California. So, and that matters a great deal. I mean, I know the sheriff doesn't do this anymore because they were enjoined by the Ninth Circuit, but they used to pull over tribal police officers in Riverside County for impersonating police officers and charge them with felonies. So local governments, Minnesota, Wisconsin, Oregon, Nebraska, you're going to have real trouble there. But we have that in Michigan too. So I don't think Public Law 280 is the cause of that. I mean, Grand Traverse County, Manistee County, they refuse to sign cross-deputization agreements with tribes because they're just straight up fat Southern sheriffs and they don't want to do it. And you're going to have that regardless of Public Law 280. It's just my opinion.
As the resident Californian, I'll say I think I strongly agree with that. I think, we've done some work with the Yurok tribe up north in California, and I think California is such a big, sprawling entity. One of the things that's striking is I think you're seeing a lot of moves at the state level that really, because it's such a blue state, have embraced tribal sovereignty. But a lot of these are a lot of tribes are actually located in the red pockets of California, and so it's very county by county. I mean, even the difference between Humboldt and Del Norte and the way that they interact with tribes, or Riverside versus LA County, or it's very different based on the sort of complicated negotiations with local government. So I think that's something that struck me as someone who's lived in California about 8 years now, is just seeing how much the idea of a state, especially one as big and sprawling in California, having unified policy just is misleading, and how much of this plays out at these intensely local fraught confrontations.
Hi, this is Amelia Flores, Chairwoman of Colorado River Indian Tribes. I just want to make a comment, and that is for our tribe, which has land in California, just like my relatives up on Chemehueve. But we work with the County of Riverside, which is our western boundary lands, and they work with us because they don't have enough manpower to cover that rural area of the county. So that's how we work with them. And sometimes it's, when changeover of chiefs of police, we got to reestablish the relationship, but it's true, establishing that relationship and keeping it ongoing. So I just wanted to make that comment. But we have our lands also in San Bernardino, and that's another story there. So thank you.
Great. Any other questions from the audience? Anybody? Okay, well, following up on the point that Chairwoman Flores just made, I think it would be a great way to sort of end this discussion, because we're almost at time, to talk a little bit about how the role that facts play in a lot of these cases and the outcomes. We had one particular case this term where I think the facts were so egregious that it gave the court sort of some of that leeway to be result oriented and result driven in the Lac de Flambeau case. But where we see these disputes between law enforcement entities from different sovereigns, creating some good facts and good records, maybe. Do you see that playing a role in how the court looks at these cases and maybe preventing some of the potentially disastrous outcomes that we've seen in the past?
I have a lot to say about that.
Yeah, we need another half an hour, maybe.
No, I'll try to be quick. Okay. So, yes, the facts of cases really matter. And we were really worried in the Brackeen case. A lot of Indian child welfare cases that start up in state courts are sealed. And what I know personally, I've seen it so many times, is that opponents to tribal sovereignty will lie to the Supreme Court about facts. And they do it all the time. And they tried to do it in this case, but some of the facts were sort of leaked by the other side, interestingly enough. So we were able to sort of off to the side in the amicus briefs, point out the actual facts of these adoptions that were being challenged in the Supreme Court. But at other times, tribes are usually behind at a huge strategic disadvantage at an early stage of these cases. And here's what happens. Non-Indian or opponent to tribal sovereignty sues. When you sue, you can create a complaint. You can create a narrative in that complaint. And, later on in trial, you're supposed to be able to prove some of that stuff in order to win. But the complaint sets the whole narrative for the whole case. And what happens is tribes and the federal government or whoever in opposition to those opponents of tribal sovereignty will move to dismiss that case or move for summary judgment. So we're not going to go to, what that means is there's not going to be a trial where you have witnesses and testimony. Nobody really wants to do that because it's really expensive. Well, what that means is that as a strategic matter, the narrative of the complaint is what really happens. So in the complaint, you can make an allegation of an outrageous fact that is plainly not true, but that's where we end up. And when we get to the Supreme Court years later, the appellate courts assume that the complaint is true. And so that's why we're often at a huge strategic disadvantage at the Supreme Court, because almost all the time, all they see are facts that have never been proven. There's no record, and they're outrageously hostile to tribal interests. And so they're always looking, the Coughlin case, one of the allegations was Mr. Coughlin alleged that he tried to commit suicide because of the tribe's lending practices. Now, that's an outrageous fact. I don't know if it's true or not. It never went to trial. These cases do not go to trial. But when they do go to trial, and often it's in tribal court, where your judge is somebody like BJ Jones, and he does not take any shit from anybody, then you create a factual record that the Supreme Court has a really hard time ignoring, and where it's actually much more true to what actually happens in these cases. And that matters a great deal at the Supreme Court.
Melody, Greg?
I'm not sure. I guess part of it is most of my legal practice has been law in motion. So I'm not good with facts. I'm not good with witnesses and exhibits. I'm not a trial attorney. I'm kind of a ditz with those things. I like it when it's just me and the judge and the law, except when it's the Supreme Court. But I will say this about the Supreme Court. Speaking of facts, I mean, the court has been called out by mainstream media or other media in this term for the kind of thing that Professor Fletcher alluded to, and that is suspect facts in a case that gets to the Supreme Court. And that's an issue. I will say my own experience in the U.S. Supreme Court, there's a line in the Strait case. For those of you who are familiar with that, in Indian law, that was the case I argued back in the decision came down in 1997. And of course, Justice Ginsburg wrote that opinion, and there's a part in the case where she says that this involved the jurisdiction of the 3 affiliated tribes in North Dakota's tribal court over a tort claim, an auto accident between 2 non-Indians, although one of the non-Indians had considerable connections to the tribe. The other was a contractor that was working on building a school, then BIA, now BIE funded school on the reservation. But there's a line in the case where Justice Ginsburg, writing for the 9-0 majority, says that the purpose of the easement, which was at issue where the auto accident arose, to go to the school at Twin Buttes, was to grant non-Indians access to the Lake Sakakawea, which is the big 1940s public works project that devastated the reservation to provide a source of water by damming up part of the Missouri River. She cites no authority for that, because there is no authority for that. That was not the purpose of the easement. The tribe, 3 affiliated tribes, had asked the Bureau of Indian Affairs to pave that road so that the school, the Twin Buttes, the BIE funded school, could be accessed by tribe members. Non-Indians don't go to that school. It's a very remote Indian community. And the BIE never got around to it. So finally the tribe said, to the state, can you pave the road? And they did. And so that's why the road got paved, but it had nothing to do with granting non-Indians access to the lake, right? So, I mean, that's an example of the court making up facts. And that's a risk. So I totally agree. I mean, Plains Commerce Bank, the case that was referenced earlier, is the only tribal court jurisdiction case that actually went to trial on the merits in tribal court. Most of these other cases do come up on motions to dismiss. And that's one of the things the Tribal Supreme Court Project is trying to work on, is to help tribes at the lower level, if we had the resources to pull the Tribal Supreme Court Project work down to the lower court levels, to try to make better records in the lower courts, because by the time you get to the Supreme Court, it is way too late to affect that. So as much as I don't like facts, I've certainly seen how they can come into play.
Can I add some more? I mean, I really think that the Creek Nation and McGirt won the McGirt case because of the amicus brief filed by the tribe, which detailed how the reservation is governed. Oklahoma is a state. It is presumed by the United States Supreme Court that Oklahoma is competent at governing its state, but they're not. And the tribe was actually able to prove that the superior government within Creek Nation Reservation was the Creek Nation itself, not the state of Oklahoma. And they showed that using facts. Oklahoma just said, Creek Nation sucks, listen to us. And they were totally lambasted at the Supreme Court, and justifiably so. You know, the court is always looking for a reason to find or make up facts to be hostile to tribal interests. I know you brought up Strait. I have to say, I thought you did the best you possibly could in that case, given the overwhelming amount of bullshit coming from the other side. Do you remember? I saw the transcript and listened to it. Justice O'Connor asking you, what about a tribal court where the jury consists entirely of cousins of the plaintiff? That there are no fact patterns in the history of tribal courts where that is the case, at least anybody that you can cite to. But that's the kind of facts that they presume about Indian people that are rooted in colonialism and outright bigotry. And that's what they will do in the absence of a clear factual record in opposition to that.
So can I add one very quick thing on this fact question, which is one way Supreme Court litigation differs from other kinds of litigation is that you also, I think, need to be thinking about a media strategy. Matthew alluded to this earlier, but I think one of the things about both Burkeen and McGirt was they got a lot of media attention. And the media attention matters. The clerks for the Supreme Court read the coverage. This is, in fact, there's a term for this. This is shadow briefing, right? Where people are sort of litigating via blogs and via newspaper coverage. And so I think it's really important to have a media strategy and try to get favorable presentations in prominent mainstream media news outlets. I think it shapes the way the cases get received and can make a difference to the outcome. And I think that I think part of that is on us academics to try to narrate this effectively. One of the things that's striking, Castro Huerta, for instance, anytime I talked to a reporter, it took 20 minutes to explain the jurisdictional rules. I could feel their eyes glazing over on the phone. And that's a really, it's very hard to try to figure out how to explain the stakes to tribes. But I think we need to get very good at presenting compelling narrative, media narratives. I think one of the heartening things about Burkeen was the effectiveness of Rebecca Nagel and the This Land podcast in sort of presenting a story that countered some of the stories that Oklahoma and others were trying to seed, and that and Texas was trying to seed. I think Matthew has done tremendous work in bringing attention to this, but I think we need to. I think there needs to be a strategy at the outset to try to make sure that we're reaching out to reporters, we're building those networks, we're making sure that the coverage is there. And even for cases that, don't get as much attention as Burkeen, I think one of the reasons that Castro Huerta came out the way that it did was because it was sort of a bit of a sleeper case and presented also as, oh, they didn't overturn McGirt, which I think is downplayed, I should say, the tremendous stakes for tribes in the legal outcome of that case. So, I think this is something that's really important as we're thinking about facts, is not just how we present facts to the court, but how we get, present those stories to the broader public as well, and make sure that there's broader public support. Because again, I think that shapes the court's thinking on these questions.
Well, professors, I'm all for good scholarship. We certainly need that, and it can be really helpful. I'm less enamored sometimes of the media. And I think, you mentioned Burkeen. I'm not sure in an equal protection setting, if that is going to come up, how the mainstream media can best handle that. So I agree that it's going to be even more important to have the communications media in place when that does come up.
The Indian child welfare case that went up in 2013 they were on Dr. Phil and just hammering us with crazy racism. And, Dr. Phil is just a POS. I can't stand just saying the guy's name anymore. But that's the kind of thing that when Burkeen came around, we were ready for that sort of thing. We started, some of the trial attorneys who were doing I should say frontline ICWA litigation, started filing motions for sanctions with the trial judges and claims in the state bar against attorneys who were trying to use the name, image, and likeness of foster children, putting them up in the media, like in front of Dr. Phil, and saying, these are the kids that the Indians are trying to take away. And, you know, that's illegal. I mean, it's so unethical to do stuff like that. When I say they make facts up, they also do really unethical things like exploit people's personal lives in order to win cases. And, you know, there was great success, I think, when Brackeen came out, that sort of ended all of that. And yes, Rebecca Nabel did great with Brackeen, also with McGirt, because remember the narrative about McGirt was 40% of all the land in Oklahoma is now Indian country. And all that meant was jurisdiction. We can now that the federal government could prosecute Indians. That's the only change. If it was 40% of the land was turned over back to the Indians, I would have applauded that. Good for the Oklahoma, the Oklahoma tribes, but that's not real.
It wasn't
That didn't
title.
happen.
Yeah, it was jurisdiction. Yeah.
Right. I think there's a lot more to say about all of the things that you just raised in that last comment, each of those last comments from each of you. I wish we had more time to do that. But, you know, thinking about how we humanize the Indian interests in these cases and humanize tribal sovereignty and, you know, drive home that this isn't about these nebulous entities that are going to impact individual white Americans, that everybody here is a human and they have rights. And that, you know, that's how we begin to shift the narrative, and that's how we begin to curb the chipping away. So thank you for your comments and for your thoughtfulness on these issues.